And Your Honor, I believe with that affidavit, the burden does shift to the state to make their case in this context.
That's correct, Your Honor. At this time, the state would call Deputy Ariel Plank to the stand.
Thank you, Deputy.
I would ask that the rule be invoked, Your Honor.
Okay, for those of you in the courtroom that may testify in this case, the rule of sequestration has been invoked. That means that you can't speak with one another or with anyone else about the case until you're called to testify. You can speak with an attorney one at a time before that time, but until the end of this hearing, until you're released, you can't speak about the case with each other or with anyone else. So if you'll please step out of the courtroom until you're called to testify.
Cameron, you just want to step out, go outside, and once you're going to testify, I'll leave you.
Can you raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Deputy, can you please state your name for the record?
Ariel Plank,
And where are you employed at?
Okaloosa County Sheriff's Office.
How long have you been employed at the Okaloosa County Sheriff's Office?
Coming up on 4 years.
Okay. Were you working the night of April 22nd, 2022?
Yes, sir.
I actually believe it's the morning of April 22nd. I'll correct that for the record. Where were you working at?
I was working on off-duty detail in Destin,
Okay. Where at specifically?
Coyote Oakley.
Did you happen to come into contact with the defendant, Mr. Jonathan Lambert, on that night?
Yes.
Okay. Can you describe how you came into contact with him?
I was approached and said there was a disturbance in the back side of the bar. And that's when I went inside, and the bouncers had flagged me down and pointed at the defendant.
Okay. Did you perform an investigation, or did you apprehend the defendant at that time?
Yes, sir.
After you apprehended the defendant, did you perform an investigation?
Yes, sir.
As part of that investigation, did you observe a surveillance video?
Yes, sir.
Your Honor, I believe, and you can correct me if I'm wrong, Mr. Kloss, but Mr. Kloss stipulated this is a Coyote Oakley surveillance video.
That's correct, Your Honor. I'm stipulating.
Submitted into evidence as it states Exhibit 1.
State's Exhibit 1.
Yes, sir, it's admitted.
I'm just going to play that video. It shouldn't be too long. And there's no audio, so I don't have to worry about that. Let me go ahead and stop it. Is that the surveillance video that you viewed that night?
With the exception of me running in, yes, sir.
At any point on the surveillance video, did you see the victim become aggressive towards the defendant?
Not one time.
At any point on the surveillance video, did you see the victim become aggressive towards anybody else?
At no point.
At any point when you were investigating this after the incident, did you observe the victim be aggressive towards you or anybody else?
No.
At any point in the surveillance video, did you see a weapon of any kind that was possessed by the victim?
No,
At any point in time during the night after the incident occurred, did you see the victim possess a weapon or hold a weapon?
no.
What did you observe the defendant do on the video surveillance?
I observed the defendant hold a beer bottle and then re-grip the beer bottle and strike the victim in the head.
You just watched the video. Approximately how much time was there between when the victim was separated by the bouncer and when the victim was struck with the glass bottle?
I don't know definite time, but maybe 30 seconds-ish.
Would you say that's an appropriate amount of time to de-escalate a situation?
Yeah, the victim never escalated a situation.
At any point, did you feel like the defendant was defending himself or some member of his group from the victim?
No.
Calls for speculation, objection.
Sustained.
I have no further questions, John.
Mr. Potts.
Deputy, would it be fair to say that you didn't hear any of the words that were passed between the individuals in this video that we just watched? Is that correct?
Correct.
Okay, so you can't provide any testimony as to what was said, can you?
No.
Okay. And there's some portion of the scuffle that happened before the video actually captures the frame of this area. It seems that the two people initially coming from outside of the frame come inside. You can't testify as to what happened before the two people came into the frame, can you?
No, sir.
Okay.
And I would like to add, I tried to get that video and that video camera was down.
Understood. And did you talk to any of the witnesses in the case? Do you remember who it was that you talked to?
Spoke with Kinsey Maloney.
Okay. And you,
Ryan.
I'm sorry, I didn't hear
Kinsey
you.
Ryan or Ryan Maloney.
Did you speak with anybody else?
And not that's named in my report.
And you were the lead investigator in this case, is that correct?
The lead case officer, yes, sir.
Okay, so you were the one responsible for this particular investigation, is that correct? Now, you would agree with me that there were more individuals involved in this scuffle in the bar besides Mr. Lambert and Mr. Hennessy, who's the complaining witness in the case. There were more people that were involved in the fight that we just watched on this video, right?
Yes, sir.
And you had the video, would it be fair to say you had the video within maybe 20 minutes after this incident happened?
Roughly, I don't know the definite time.
Certainly you had it within an hour of the incident happening, correct?
Yes, sir.
And Mr. Hennessy and all of his friends, Mr. Hennessy in this particular case is a complaining witness. Mr. Hennessy and all of his friends were still on the scene, correct?
I don't know where his friends were.
Okay. You didn't talk to any of his friends at all?
I spoke with Mr. Hennessy and there was one female that was with him.
Okay. Were you aware that Mr. Lambert was still on scene with his friends that were also in this video?
I don't know who was all friends with anyone. I had two groups surrounding me.
Okay, did you make any, well, let me just, Your Honor, may I address the prosecutor just about a logistical issue? I know that's not always, I just, what I was going to say is I can use my computer if you don't mind if I use your computer just to move the video forwards and backwards. Instead of changing up computers, Judge, I've got the same video, but I just wanted to see if this thing would be okay. And Deputy, this is the video that you were able to recover from the actual Coyote Ugly bar camera system.
Yes, sir.
Correct. And if I remember correctly, I think this is actually your body-worn camera is taking a video of a computer screen in the office. Is that right? Or maybe
Yeah, it's either body camera or cell phone. It's one of the two.
because so this is not the actual original video. This is
Yes, sir.
you're holding a camera taking a picture of a computer screen when this happened.
I was unable to get a burned USB or CD.
Understood. And so if you can look where, would you agree with me where I'm pointing? Are you able to see the cursor as I move it?
You can stand up if you want.
Yes, sir.
Can you see the pointer that I'm using?
Yes, sir.
Would you agree with me that this is Mr. Lambert, the defendant right here? That I'm
Not
pointing
at
to?
this point in the video, no, sir. I'd have to see him walk.
Okay, I'm going to move it forward just so we can identify who some of the parties are. Excuse me.
Yes, sir.
Okay, so we've identified at the very beginning of the video, before there's any fighting going on, that the defendant is actually standing. I'm going to point to him. This is 0000 on. Okay. On State's Exhibit 1, we're at timestamp 0000. You would agree with me that this is the defendant, Mr. Lambert, right here, correct?
Yes, sir.
Okay. And did you ever find out who this person was here in your investigation? Did you ever try to find out who this person was? With the white shirt and the white hat?
If he was affiliated, then outside possibly, but I can't identify who it is.
Okay, do you have his name in any of your reports?
No, sir.
Okay. I'm going to move the video forward. Okay. Now it looks, to the best that I can tell, two new persons have come into the frame. These two people over here, and you would agree with me that this person who has what appears to be khaki pants, shorts, I'm sorry, and then a shirt that are Hennessy. Did you ever make an attempt to find out who it was?
I asked Mr. Hennessy if he wanted to pursue charges. He said no. At that point, I did not have a crime for that battery.
Okay. Well, isn't it true that Mr. Hennessy told you that the person who pushed him against the bar was the one who slapped him with the bottle? Isn't that true?
I'd have to look at my video.
Okay. If I were to show you Mr. Hennessy's statement, sworn statement, would that help refresh your memory? Okay. May I approach the witness, Judge? Excuse me. Do you recognize what that document is?
Yes, sir.
Okay, and that's a sworn document, is it not?
Yes, sir.
And that's the sworn document that was provided by Mr. Hennessy, correct?
Yes, sir.
Does that help refresh your memory about who Mr. Hennessy told you pushed him into the bar and hit him with the bottle?
Yes.
Okay, now that you've refreshed your memory, what did Mr. Hennessy say about the man who pushed him into the bar with respect to whether that was the man who hit him with the bottle?
Struck him with the bottle.
Okay. And it's true that Mr. Hennessy in his sworn document said, and I'm not going to read the whole thing, but the pertinent part is, in the sworn complaint of Mr. Hennessy signed under oath says, suspect shoved victim into the back of bar and struck victim with beer bottle which broke on impact with his face. Correct?
Correct.
Okay. So Mr. Hennessy told you that the man that I'm going to point at on timestamp 004, the one who pushed him into the bar, he said that was the guy who slapped him in the face with the bottle. Isn't that true? In his sworn document?
Correct.
Okay. I'm going to move the video forward a little bit more. Okay. Now let me see if I can back it up just a second or so. Okay. In addition to the complaining witness and the man in the black t-shirt, I've had two new people that come into the screen at this point. I'm going to point to this very tall gentleman very muscular with a bald head. He's one of the bouncers at the bar, isn't that true?
Yes, sir.
Do you know his name?
Satchel, I think is what they call him.
Satchel?
Mhm.
Okay. And so then there's another, and I didn't do a good job of stopping it, I'm pointing at the back of a young man's head here. This is a taller, blonde young man. Do you recognize him?
No, sir. I can only see the back of his head.
Okay, I'm going to back up a little bit. Now, so that young man that I described as a tall, blonde-haired young man, he has what appears to be a black shirt and khaki shorts and tennis shoes. He just threw the man to the ground that pushed the victim into the bar, didn't he?
Yes.
Okay. So the man, Your Honor, may I ask Counsel Opposite something real quick?
Sure.
Okay. Your Honor, what I asked the state attorney was, I know the names of these people, and it would probably be helpful to the court if I just use proper names instead of using the clothing descriptions.
Yes, sir.
If I could do that, the state did not have an objection to that.
Sure.
Okay. So we have Satchel here, who's the tall bouncer that has bald head. We have this unknown gentleman right here, who's wearing khaki shorts and a black shirt, whose name I don't presently know. We have, I'm pointing to a timestamp 0007. This right here is Cameron Hennessy, the complaining witness, correct? Then I'm pointing to where somebody's holding an arm across their chest. Is that correct? Right now in the screen capture that we're at 007, the complaining witness, Mr. Hennessy, has got his back against the bar, is that correct?
Correct.
And there's a gentleman that has his arm across his chest. And then behind, and this, just so you know, this gentleman's name right here, who's got his arm across Mr. Hennessy's chest, Your Honor, his name is Troy. And just for the purposes of the examination, I'll just refer to him as Troy. And then behind Troy, we can still see Mr. Lambert is there, correct? Behind Troy?
Or something, I don't.
I'll make the video move so you can actually see it.
Yeah.
You would agree with me. So now, Mr. Lambert, even though Mr. Hennessy, the complaining witness, is being held back by a man named Troy, Mr. Lambert is just standing there, isn't he?
Yes.
And except for the point where Mr. Lambert appears to hit Mr. Hennessy later in the tape, there's no other contact between Mr. Lambert and Mr. Hennessy, the complaining witness, is there?
No, sir.
Okay.
Well, other than physically, no. Verbally, I don't know.
Okay. So you leave room for the possibility that there's a verbal exchange between Mr. Lambert and the complaining witness, don't you?
I don't know.
Now, I'm sorry, I went too far. I'm backing up to timestamp 006, and we see the unknown, I'm just going to call him the tall blonde gentleman with a black shirt. We see him grab the man who pushed the complaining witness to the bar. His name is Tyler, and throw him to the ground. Would you agree with me that this unknown man in a tall blonde-haired guy in a black shirt throws Tyler to the ground? Can you see that happen?
Yes.
Did you have any knowledge that when that tall blonde-haired young man with the black t-shirt on threw Tyler down on the ground, it broke his wrist?
I have no knowledge.
Well, you have the video though, right? I mean, you were able to see what happened.
Yes.
And did you make any attempt to talk to the tall blonde-haired young man in the black t-shirt?
There were so many of them, sir. They were all outside.
Okay, they were all outside though, weren't they?
Some of them were.
Okay.
I had two groups.
And the man who got thrown to the ground was also outside, wasn't he?
I don't know. I did not witness him get thrown to the ground.
You have the video, right?
I understand what you're saying, but I did not see him afterwards.
Did you make any effort to try to identify who he was and what his injuries were?
No, sir, I didn't know he was injured.
All right, I'm going to move forward. We're at timestamp 009. Now, I want to... Okay, we're at timestamp at 10 seconds. I want you to see if you can identify. Okay, here we come in. There's Mr. Lambert right here walking away from the complaining witness who was right here behind Troy. Do you recognize the complaining witness? I'm pointing the pointer at him at timestamp 14. The complaining witness is still here with the gentleman with the white hat and light colored shirt. His name is Troy. That he's still there, and Troy's holding his arm across the chest of the complaining witness. You would agree that's what we're seeing, right? Yes, sir. And then Mr. Lambert is walking completely away from the victim, isn't he?
He's walking away, yes.
Yeah, and he's got 3 beers in his hands, doesn't he?
I don't know what he has in his hands.
Well, if I back it up a little bit, can you help me identify what's in his hands? Because you can, I know the video's hard to see.
I can see 2 beers. I don't know if there's 3.
Okay, so we can see at least he's got 1 beer in each hand, and he's walking around to the other side of the bar, completely ignoring Mr. Hennessy, isn't he? Well, as best as we can tell. He's not really paying any mind to what's going on there.
Yes, sir.
And he's going around to the other side of the bar with a couple beers in his hand that it looks like he had just bought before. Is that correct? Yes?
Yes, sir.
Now we can still barely see, we're at timestamp 17 seconds, we can still barely see, this is essentially, I can back it up if you need to, but this is the elbow of Mr. Lambert right here, 17 seconds, correct?
Correct.
Okay. And, let's see if we can move forward to see Mr. Hennessey's. Okay, at this point, there's another scuffle that breaks out around the dog leg short end of the bar. Isn't that true? And just for ease, can we say the long side of the bar is where Mr. Lambert walks from, and then the short side of the bar, because it's an L shape, right?
I believe so.
Yeah, so we can just say short side of the bar is over here, and then the long side of the bar is up here. Apparently, there's another fight that breaks out over here on the short side of the bar. Is that correct?
Correct.
I'm going to back it up just so, because I know it's hard to see, Your Honor. So can you see that there's another gentleman getting punched in the face over there on the short side of the bar?
I don't know if he's getting punched in the face, but he's leaning up against the bar.
You can see that he's being beaten, can't you?
Object to speculation.
Sustained.
I'm going to back it up to timestamp 17 seconds. Now, right here, that head that we see right there, do you recognize that to be where Mr. Lambert has gone?
I cannot positively identify him, no.
Understood. And then would you agree with me that at timestamp, 26, we are now looking at the back of the complaining witness, Mr. Hennessy, right here. Is that correct?
Correct.
And I know this shirt didn't come out very well in the video, but it's actually like a blue and white striped shirt.
Right. Yes, sir.
But it doesn't look that way in this video, for whatever reason. Is that correct?
I didn't make the video.
So this is Mr. Lambert right here, correct?
Correct.
This is Mr. Hennessy right here, correct?
Correct.
Do you see Mr. Hennessy lifting up the back left side of his shirt?
Pulling up his pants.
Do you see that his shirt is going up?
His shirt is raised.
Okay. Now, let me ask you a question. You've been trained to be very observant as a law enforcement officer, is that correct? And you were trained to recognize threats on the street, is that correct?
Correct.
If you had just been in an altercation and you saw somebody come up to you or standing near you, and I'm not going to do anything to you, but if you saw somebody come up to you on the street standing like this and go like this, what are you going to think?
The defendant is looking away, so he doesn't even see
That's
the
my
victim.
question. If I come up to you on the street and do this and you don't know me, what are you going to think if I start reaching behind my back?
Let me see your hands.
About what?
Let me see your hands.
Why?
The unknown.
It's a threat to you, isn't it?
It's an unknown.
It's a potential threat, isn't it?
Objection, asked and answered.
Sustain.
Okay. We're at timestamp 37 right here. At the time that Mr. Lambert hits Mr. Hennessy with the bottle, Mr. Hennessy has his hand back here under his shirt, doesn't he? Isn't that what the video shows?
It's on his hip.
And his shirt is up in the back, isn't it?
It is raised, yes, sir.
That whole time he had his hand behind his back, didn't he?
It was on his hip.
On his hip.
Inside.
Now, do you know whether he had any type of weapon on him at this moment in this video?
I do know when you enter the bar, you have to go through a pat down and a security scan. So like medical, the like handheld medical detector, they swipe your body and then the bouncers physically pat you down.
Okay. Do they do that every single time? And can you testify that they did that to Mr. Hennessy in this
I
case?
cannot testify. I can only tell you what I've seen in the past.
Okay. Did there come a time when you walked up to the ambulance where Mr. Hennessy was receiving treatment and asking some questions?
Yes,
Okay. And you recall asking whether they were able to catch the guy who did it? Did you hear that particular conversation with Mr. Hennessy?
I'd have to refer back to my body camera. I don't recall.
Do you remember Mr. Hennessy telling you or another law enforcement agent that he hoped that kid dies, referring to Mr. Lambert?
No, sir.
Did you ever hear that in the video or hear Mr. Hennessy say that?
No, sir.
Is it fair to say that the only people that you talked to that are in this video were Mr. Hennessy? Did you talk with Mr. Lambert? Did you say?
I did speak with him.
Okay. And
I believe it was a sworn verbal statement.
okay. And then you talked with the young lady who said she was a witness, is that correct?
Yes.
And you didn't talk to any other witnesses besides that and take statements?
Regarding statements, no.
Okay. Nothing further, Your Honor.
Thank you. Mr. Gomez?
Just wanted to, just one point, one video. This is timestamp 37. I believe counsel for the defendant had asked you
You know, oh, he has his hand behind his back here. At this time in the video, I think you also mentioned that he re-gripped the bottle. Is that what you're seeing on this right now?
Yes.
Do people normally drink the bottle?
Objection calls for speculation.
Let him finish his question.
Yes, sir.
Do people normally drink from a bottle when they're holding it as such by the neck?
Object to speculation.
Assistant.
At this point in the video, has the defendant even seen the victim and where his hands are placed?
No, sir. He's approaching me.
And he's already re-gripped the bottle? No further questions, Your Honor?
Can you redirect?
Court's indulgence, please, Judge. Nothing further, Judge. Thank you.
And the officer be released.
Yes, Your Honor, that's fine with me.
Yes, sir.
Thank you. Thank you so much. You're released. Thank you, ma'am. Yes, ma'am. Thank you. Mr. Gomez, your next witness.
I'd like to call Mr. Hennessy, he's outside.
You don't mind Deputy getting Mr.
you have to-
Hennessy and asking Mr. Hennessy to come in?
Yes, sir.
Thank you, ma'am. Good, I thought, dang.
Please remain standing. Can you raise your right hand? Do you swear or affirm that the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth? I do.
Thank you, Mr. Hennessy. Can you please state your name for the record?
Cameron Hennessy.
Okay. And do you remember what happened the night of April 22nd, 2022?
To what I recall, yes.
Where were you at?
IODIB?
Had you been drinking?
Yes.
How much did you have to drink at the time this incident occurred?
I would say 3 beers.
Were you drunk?
No.
How did you come into contact with the defendant?
It appears after I was pushed, a scuffle or something broke out, and then as what I think to be him and his accomplices were being escorted out and kind of came face to face. And that is the first I recall of seeing this person.
Okay. When you guys came face to face, did you say anything to the defendant?
Not that I recall.
Okay. I've noticed that you said not that you recall. Is your memory a little bit fuzzy of that night?
Yes.
Okay. Was it a little bit fuzzy kind of right after you had gotten hit with the bottle?
Yes. Well, a little bit before that. When I got pushed, I hit the back of my head up against the bar. Had a bump on there for a few days.
Is it possible that after you had gotten hit with the bottle that you may have kind of like misremembered some things when giving your statement to the police?
Yes.
Okay. I'm going to play some bits of the video here. I'm just going to want you to kind of help us identify some people. So I'm going to just start it at 00 and play it until about, let's see here. Okay. This is the first time that we see you come into screen on this surveillance video. Do you by chance know who it is that was pushing you?
Not like, personally, I believe it to be a friend of the defendant.
But you don't know for certain? Okay. How did he come to be pushing you?
He was talking to a friend that I went down there with, and I walked up. They weren't fighting or anything, but it looked like they weren't getting along too well. And I walked up, said what was going on and stuff, and this person seemed very like pretty angry, honestly, and rude right away towards me. And then what I remember, something along the lines of like, "You don't want to mess with us," and I was like, "Oh, like what are you gonna do?" Like, and that's about all.
Is that when you were shoved into the bar?
Yes.
I'm going to continue playing the video from point 05. Okay. I kind of stopped it a little bit blurry, but there was an individual who came in and grabbed the individual pushing you. Do you know who that individual is?
Yes.
Who is that individual?
That is my sister's, my girlfriend's older sister's boyfriend.
And what did he do exactly during this part of the video?
From what I know, and he just shoved the guy down.
So he didn't take a bottle and hit that guy in the head because he was touching you, right?
No.
Okay. Okay. At this point in the video, there are two individuals right around you, is that correct?
Yes.
Do you know the individual who has his arm out on your neck?
I do not.
Was that a member of your group?
No.
Do you know the individual, or do you recognize the individual that appears to be right to the right of your shoulder by the bar?
From the video, I know that it's the defendant.
Okay. At this time, were you aggressive towards the defendant in any manner?
No, and I believe the video would show that because after someone puts their arm around your neck, I looked pretty calm and remained pretty calm the whole time, I would think.
Okay. I'm going to stop it over here. I think you can see around the bar, there's another altercation that's happening. Is that correct?
Yes.
What was happening?
I do not have any recollection of what happened right then and there because just of when I got hit in the face, I do not remember.
Okay. Was one of your friends involved?
I don't remember, but I believe so.
Okay. What are you doing here at this point in time in the video?
Like I said, I don't have full recollection, but it looks like I'm just kind of seeing what's going on, see what's happening.
All right. Would you categorize yourself in an aggressive posture?
I would not.
You just performed an action, and I just wanted to know, what was that action? It seemed that you were reaching by your waistband. What exactly were you doing?
I put my hands on my hips.
Okay. Did you have a weapon in your waistband by chance?
No.
Do you recall if you ever told somebody that you had a weapon?
No.
Did you ever threaten anybody with a weapon?
Not that I know, no.
At this point, it looked like you and the defendant came face to face for a brief moment. Do you recall the defendant saying anything to you?
Not that I remember, no.
Do you recall saying anything to the defendant?
Not that I remember, no.
Is this you still with your hands on your hips?
Yes.
Okay. By this point in time, about how many seconds had gone by between when you were shoved into the bar and you get to this point?
I would say like 30, 40 seconds.
Would you say that in terms of your involvement in this altercation, you were pretty much, you had been kind of de-escalated and you were done with this situation?
Yes.
And you were just simply standing to the side with your hands on your hips?
Yes.
At this time, did you have any knowledge that the defendant had re-gripped the beer bottle that he was holding?
No.
Is the defendant looking away from you at this point?
Looks like it.
On that frame right there, I want to pause it at 40 seconds. Is the defendant being pushed out by the bouncer?
Here so.
Is the defendant also have his friend that was the one that actually pushed you, correct?
Yes.
And you and that friend are showing no aggression towards each other.
Yes.
Does it appear that that friend is actually trying to get the defendant out of the bar?
Here so.
What is that friend doing now to the defendant?
Looks like he's trying to push him away or out of the bar.
So the friend doesn't appear to be concerned for his safety, and the defendant doesn't appear to be concerned for anybody's safety.
No.
What type of injuries did you suffer as a result of the incident with the defendant?
I had to get 60 stitches in my face that night. Severe swelling for weeks. Obviously a scar for life. Some nerve damage in my left side of my face. Can't smile straight now.
So, is it safe to say that your only physical involvement with this was in the very beginning when you were shoved into the bar by somebody other than the defendant, and that was that?
Yes.
And then you showed no more aggression or were involved in any form of aggression until you were struck in the face with a beer bottle?
Yes.
I have no further questions.
Mr. Hennessy, you would agree that not long after you went outside of the bar, you gave a statement to a deputy and told them what happened. Do you recall that?
Yes, what I thought happened.
Okay. Well, you actually signed a sworn affidavit, didn't you?
I guess so, yes.
And the sworn affidavit, you put your signature on it, correct?
I would think so, yes.
And you swore that everything that was contained in there was the truth, correct?
That I knew of, yes.
Okay. And it's true that the testimony that you're providing today is different than what you initially told law enforcement when they interviewed you, is that correct?
Yes.
And you're saying it's because you were having memory problems at the time, is that correct?
Yes, right after it happened, I really didn't know what happened, how I got hit, or anything.
Well, if I may talk about that a little bit, you said a couple times in answers to the state attorney's questions that not that you remember, so there's a lot that you don't remember, is that correct?
This is that, yes.
Did I hear you correctly when you said that you're not able to remember what, if anything, that you said to Mr. Lambert before he hit you? Isn't that true?
Yeah, you could say that, but it looks in the video that he's looking away from me and I'm not really looking at him also.
Yeah, but that's my question. My question is simply, you don't remember what, if anything, that you said to Mr. Lambert before he hit you. Isn't that true?
Sure.
Okay. So,
Let me interrupt you. Probation, I don't think there's anything else that you need to be here for.
Maybe,
In the future, stand up and say, Judge, can I go? Because I don't think there's anything else. Okay. Thank you, ma'am. I'm glad that you had that call. Thank you, ma'am. Mr. Cox, please.
yes, thank you, Judge. So it's fair to say that you may have said something to Mr. Lambert before he hit you with the ball, and you're just not able to remember it. Isn't that true?
Possibly.
And when the state attorney asked you if you had made any threats to him, to Mr. Lambert, before you got hit, I recall your answer is not that I can remember. Is that correct?
Well, yeah, I said that, not remember, and if you look at the video, it doesn't look like I ever really touched or saw him while I walked over there.
I know, but my question was, did you say anything? And we're looking at the back of your head, right? So we can't see whether your
I'm
mouth is
saying
moving.
that I would say no because I never even came in contact with him until that moment, so I would say no.
You were interviewed at some point by an officer when you were in the back of the ambulance, and you said that you hoped that Mr. Lambert died. Why did you say that?
Angry.
But you don't deny that you said that, correct?
No.
Besides the part of the video where it appears that Mr. Lambert hits you with the bottle, do y'all have any other interaction?
No.
Do you have any idea why it would have been that he hit you?
Objection, speculation.
I can rephrase, Your Honor, and to ask it better. Do you have any personal knowledge from any interaction with him or witnessing anything that evening that would give you personal knowledge as to why Mr. Lambert would have hit you with the bottle?
No.
Could it have been that he perceived you as a threat?
Maybe.
I didn't hear you.
Maybe.
And why maybe would he have possibly thought of you as a threat?
I mean, anyone could think of anyone as a threat.
I'm sorry?
Anyone could think of anyone as a threat.
Okay. And in this particular video, I'm going to back it up. I'm going to stop right here. We're at timestamp 4 seconds. I'm pointing the pointer. That is you right there, correct?
Yes.
Okay, and this young man with the light-colored hat and dark-colored shirt on is the person that you said pushed you into the bar. Is that correct?
Yes.
And I believe, if I recall your testimony correctly, you said that there was some type of interaction with this young man. And just for the purpose of this hearing, his name's Tyler. We'll call him Tyler, just have a name. Tyler, and you were here at the bar. What happened with you guys? What happened before you guys got onto the screen?
I said earlier he was talking to a friend of mine. They weren't getting along. I walked over. What I said earlier happened.
You grabbed him, didn't you? You grabbed Tyler, and that's why he pushed you into the bar. Isn't that true?
No.
You deny that?
Yes.
Okay. This person right here, we're at timestamp 6 seconds. Blonde hair, taller, young man with a black shirt and khakis. I think you said that it was your girlfriend's older sister's boyfriend. Did I get that right?
Yes.
What's that young man's name?
Tyler.
Tyler what?
Hoppus.
Spell it for me.
I think H-O-P-P-E-S, I think.
H-O-P-P-S?
I think. E-S.
H-O-P-P-E-S. What city does he live in?
Lincoln, Nebraska.
Is he still dating your girlfriend's older sister?
They're engaged now.
They're engaged? And you see him coming into the screen here. So we've got 2 Tylers. You would agree with me that your Tyler from your group throws the Tyler from the other group to the ground. Is that correct?
Yes.
Did you know that when Tyler Opus, is that how his name is pronounced?
Hoppus.
Opus threw the other Tyler to the ground, that he broke his wrist?
No.
Did you ever go check on the guy that got thrown on the ground?
Are you talking about like right after or like after we were outside?
Either.
No, when we were outside, I was bleeding profusely and had a bunch of people asking me questions, so I didn't get the chance to do that. And after in the bar, it looks like up there, I was staying away from the situation. And why would I go see what he was doing if that's the dude I was coming into an argument with?
I'm going to fast forward a little bit. Now, up to this point, we're at 15 seconds, and we just saw Mr. Lambert walk from behind you, around you, and around to the short side of the bar. Is that correct?
Looks like it.
He didn't even really acknowledge you, did he?
Nope, neither did I him.
Didn't look like he was mad at you, did he?
Guess not.
And he was walking away from you?
Guess so.
He didn't hit you.
Not then.
And he walks around to the short side of the bar, and would you agree with me, let's just watch for a second, that you see a scuffle happening on the short side of the bar when I just played that, is that correct?
Looks like it.
And you would agree with me that there's Tyler Hopus that was over there getting into a scuffle with somebody else, is that correct?
I guess that happened. I don't remember that scuffle either from getting hit in the head.
So at this point in the video, before you got hit with the bottle at timestamp 21, you can't remember whether or not your Tyler Hopus got in another fight around the other side of the bar?
I'll say it again.
If I back it up a little bit, would you be able to see if you can identify him in the video?
Well, I just said, can you say what you just asked again?
Yes, sir.
I said yes, he's black shirt.
Yeah, the question that I have is, as we go around the short side of the bar, there appears to be another fight that's going on over there, and my question is Tyler Hopus over there in that particular fight?
Is he?
Yes.
I don't know for sure, yes or no, probably, considering he threw the guy down and then his friend went over there, so I would say yes.
And you saw somebody grab your left arm, correct? In this, right here, there's a hand that just grabbed your left arm. Do you agree with me right there? That's what just happened that we saw at timestamp 39?
Either someone's hand or my right hand.
I'll back it up and see what we can see. You would agree with me that somebody just grabbed your left arm, wouldn't you?
My left arm, no.
I'm sorry, your right arm.
I guess so, yes.
And you're standing there with your left hand on your left hip, is that correct?
Yes.
And it's under your shirt.
Yes.
Back up one more time, I didn't catch it. Okay. Right here, frame 37. You made a point a second ago that the video showed that Mr. Lambert was looking to, I guess it would be his right, but here he's looking right in your direction, isn't he?
Oh, looks like he's looking to the left, my right a little bit, honestly.
And he's actually not on video as to what he's looking at as the whole time he's walking up to you from the short side of the bar. This is one of the first times where his head is turned in your direction, is that correct?
Like I said, I think it's to the right a little bit, but yeah, it's pretty kind of close to me.
He looks back at you again there. So you agree with me, would you agree with me? I'm going to play it again because I know it happened so quickly. And looks at you once there, looks at you again, and then he hits you, is that correct?
Kind of looks like he's like looking away while he's hitting me to me.
Are you right-handed or left-handed?
Right.
So wouldn't you agree with me that the only time that you put your hand on your hip, under your shirt, is as Mr. Lambert is walking to you from the short side of the bar? In this whole video, that's the only time you ever did that?
Yes.
Course indulgence for 1 second, Judge, please. 1 second. Because you have said that you're not able to, not that you remember anything that you said to Mr. Lambert as he was walking by you, you can't deny that you said as he and his friend were walking by, I've got something for his ass. You can't deny that, can you?
No, but he definitely didn't say that.
I didn't hear you
I
at
said
all.
no, but I mean, that's not something I would say. Like, that's not, I don't usually pick those words.
You can't deny that you said that, can you?
Guess not. But, I mean,
Nothing further, Judge.
Thank you, sir. Redirect.
I'm gonna go back to around 37 seconds, or a little bit before. What did you just do right there?
not watching.
So this is right when the defendant comes into the scene again. He's actually, it's the first time we see him come back towards you. Can you describe to me your actions of what you did when you see the defendant?
Took a step back and placed my hands on my hips.
I have no further questions.
I have one follow-up question based on that particular play of the video, Judge. It won't be very big.
There's no recross, but the statement.
No, I object to it.
Okay, you can call him in your rebuttal case if you want.
No
Well,
problem, Judge.
It's your case.
That's okay, thank you.
Based on Mr. Potts, if you want to preserve it, object to the question being outside of whose witness is it?
It's the state's.
Okay, so you'd have to object that it was outside of your cross.
I understand, Judge.
Yes, sir, you can step down, may this witness be released.
Yes, ma'am.
No,
Okay.
thank you. Please.
So if you'll remain outside. Thank you, sir. So the state, any other witnesses?
No other witnesses, Your Honor.
Mr. Clyde?
Your Honor, just briefly, before I would call any witnesses, I have argument that I believe the state has not met its burden of proof at this time. The state is required to show by clear.
You'll need to step out of the courtroom and just stay out of the courtroom and stay in the courtroom.
Yeah, that they might use you for their argument, so yeah, you'll have to sit there for a little bit longer. We're gonna try to get you out here shortly.
Mr. Cox, you move for basically a directed verdict.
Yes, Your Honor. They haven't proved by clear and convincing evidence that my client did not have fear of serious bodily injury at the point. There is evidence. Court's indulgence. There is evidence that's been presented to the court through the deputy's testimony that somebody taking that particular stance would cause a concern. I understand that her testimony was not very strong, but the deputy testified that if somebody were to be standing in that fashion or approach her in that fashion, it would cause a fear of the unknown. I know I'm paraphrasing, but there is concern that was caused to Mr. Lambert by the posture of the complaining witness in this case. There is evidence about that. There is video to show that the only time that he concealed his hand up under his shirt and behind him was as Mr. Lambert was walking out. And I believe the state has to show by clear and convincing evidence that my client did not have a reasonable fear at that time that he might be the victim of serious bodily injury or great bodily harm, I believe is the standard. And I don't think they've met their burden, so we're asking for a directed verdict.
The motion respectfully is denied. Mr. Potts, your first witness.
Yes, sir. May I consult with my client for 1 second? conversations about this issue with my client about whether it would be a decision to testify or not in this particular hearing, just based on all the legal issues that are involved with that. At this time, I would like to call him as a witness.
Okay. Please, if you'll come to the stand.
Can you raise your right hand for me, please? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Okay.
Mr. Lambert, do you understand that you have the right to not testify if you don't want to?
Yes, sir.
Okay, so nobody's making you testify here today.
Yes, sir.
Okay, thank you. Mr. Bott.
Thank you, Nick. Please, court. Can you tell me your name, please?
Jonathan Lambert,
Mr. Lambert, where do you live?
Theodore, Alabama, Mobile.
And what do you do in Theodore, Alabama?
I'm a chemical operator at a chemical plant on Range Line Road.
How old are you right now?
Turned 30 2 days ago.
Okay. We have walked through this video. Can you tell me what you and your friends were doing at this bar on this particular occasion?
Yes, I was down visiting. Also was getting married the following weekend, so we were down celebrating that.
Okay. And in this particular case, you've seen, as we've gone through the video, I've described a young man named Troy and a young man named Tyler. Have I accurately identified them on the video?
Yes, sir.
And it's fair to say that Tyler is the young man that pushed Mr. Hennessy into the bar. Is that correct?
That's correct.
And then Troy was the young man with the white shirt on who held his arm across Mr. Hennessy's chest?
That's true.
Okay. I'm going to go back to the start of the state's Exhibit 1, just the video. Have we accurately identified you as where I'm pointing with the pointer here?
Yes, sir, that's me.
And this is your friend Troy right here?
Yes.
Is that correct?
Mm-hmm.
Okay. And then in the black shirt with the dark shirt with the white writing and the light colored hat with Mr. Hennessy is your friend Tyler?
Yes.
Did you know who this young man was at all? Who's we've talked about as the tall, blonde-haired young man who's also apparently named Tyler Hops, who is a friend of the complainant?
I did not know who he was at this point.
Okay. Now, when Tyler got thrown down in the next few seconds, he actually broke his wrist or broke his arm. Is that correct?
That's true. Required surgery and everything. Yeah. Yes, sir.
And are we going to see in the video that Tyler actually moves away from the other Tyler Hops to go to the short side of the bar if we continue this a little bit?
Yes, sir. Actually ran from him. That's how he ended up on the other side so quickly.
So this guy right here, Tyler Hops, who's been identified with the complaining witness, throws your friend Tyler down, and Tyler runs away from him over to the short side of the bar over here?
Yes, sir. Actually made a loop. I watched him.
Okay. And
There was a lot of people.
And Tyler Hops, who was the friend of the complaining witness, went over there and engaged him again? Is that
Oh, yes.
Are we able to see that happening when we get a little bit further in the video?
Yes, sir. On the side of the bar, you can actually see him punching him across the bar, which I tried to get Tyler so we could leave.
What we just saw right there around timestamp 21, is that your friend Tyler getting punched by Tyler Hops, the friend of Mr. Hennessy?
Yes, and I seen this.
Did you ever try to hit anybody or engage in the fight over there?
No, sir. I just wanted to get Tyler so we could leave.
Okay. And you heard us or saw us play the video where you were walking from the long side of the bar to the short side of the bar. You were holding how many beers in your hand?
I had two. I actually just bought another one for Tyler he was going to the restroom and coming back.
Okay. Now, at this point, we can see this is you that I'm pointing to at timestamp 30 right here, correct?
Yes, sir.
And you have not been throwing any punches or pushing anybody up at all?
No, sir. My only interest was leaving with my friend because he was hurt.
Tyler was hurt because he had a broken wrist?
Yes, sir. He actually told me that whenever I come over there to him, and I told him let's go, and he shook his head, yeah.
Now, can you see, I'm going to back up about 10 seconds. Can you see yourself in this video when you start moving towards Mr. Hennessy, the complaining witness? Can you tell me what you see Mr. Hennessy doing with his left hand as soon as you start moving towards him?
Yes, sir. So the bouncer was behind me and Tyler walking us out. And once I got to the corner of the bar, I noticed Mr. Hennessy standing there, and I already knew he was involved because of before. And so I stopped, and the bouncer was telling us to continue, and then Mr. Hennessy had stated what he stated, and
About what the victim stated?
Yeah, I thought he was about to say it, and I just don't even want you to hear that, so.
Well,
No, I understand. I withdraw my objection.
Okay, thank you.
what threat of violence did Mr. Hennessy say to you as you were walking by?
do I have...
Objection, hearsay.
It's not hearsay. I'm sorry.
What's the exception, or why isn't it hearsay?
It's not hearsay because it goes to my client's state of mind. To prove his state of mind is not going to the truth of the matter served. It's going to show that he had a state of mind of fear. It's also a present sense impression of his understanding of what was going on in the moment.
State?
They're trying to prove the truth of the matter asserted, the matter asserted here being that he was in reasonable fear, and they're trying to use an out-of-court statement made by somebody else, the definition of hearsay.
The objection's overruled. You can ask.
Look, I'll lay a better foundation, Judge, but I'll get to the same question. Something happened that caused you to have a great deal of fear right around the time that Mr. Hennessy was walking by you. Isn't that correct?
But yes, sir. This was my only exit. When we tried to leave, he was standing there. I already knew they had beef with each other. So I stopped, and then he said, "I have something for his ass." And when he said that, I looked at the bouncer for the bouncer to assess the situation, and all he did was shove me into him, and I had to make a split-second decision. I mean, that happened that quick.
We're going to come back to that.
Okay.
But I want to ask you a couple of questions to lay some foundation. Do you have a carry concealed weapons license?
Yes, sir.
How many years have you had that?
Probably about 6 years.
Okay. And have you had some degree of training or practice in order to be able to carry a concealed weapon in Alabama?
Formal training, I mean, I'm a member of a shooting range near my house, and I have to go through training to be a part of that. And I hunt and fish and done all that all my life, so I'm outdoorsman.
So, and you did not you did not have a firearm on you this evening, did you?
No, sir, I'm not allowed to have one while drinking.
Okay. So you didn't have a gun, but you do have, are you familiar with the term situational awareness?
Absolutely.
What does situational awareness mean to you?
To me, I never sit with my back to a door. I mean, I'm always paying attention to everything. Any kind of act of violence can be, I take everything and I look at everything.
Okay. When you see Mr. Hennessy with his hand under his shirt behind his back, with the side where he's holding his hand away from you, what does that tell you?
To me, it points to, if not a knife, at least a gun or a knife. It's perfect posture for drawing a weapon.
Okay.
To me.
And there's been some discussion about you changing your grip on the bottle. I'm going to back up 10 seconds. I'm going to try to stop when you think you see that. Okay. Did you see right there around second 38? I'm gonna back up. And Judge, I'm sorry, I can only do a 10-second jump at a time if I have it. But around second 38, we actually see you shift your grip.
Yes, sir.
And that was after you looked at Mr. Hennessy and saw that he had his hand under his shirt behind his back in a posture to draw a weapon.
That's correct. I had no other option as far as defending myself. Both my hands were full. So once I seen him do that, I'd only done that in a situation where I had to use force, and I was forced into it by the bouncer. I wasn't able to stop, and he shoved us into past the guy, which I was out of arm's reach of him at that point.
How long would in your experience in training, how long would it take for somebody to draw a weapon from behind themselves and shoot you?
Nearly instantly, especially with his hand already on it.
Did you?
And I was aware of there'd already been shootings at this place before we ever went there.
I didn't hear you, I'm sorry.
I said I was aware of shootings already taking place at this particular bar before we ever went there.
How had you heard about that?
The news. And I have family that lives in Destin.
So you had previous knowledge that that people had come into the bar with weapons before?
I don't know for sure that they've been shot inside of the bar, but I know there's been shootings at the bar.
Did you fear for your life at the time that you made the decision to hit Mr. Hennessy?
I had feared that he was going to draw a weapon on me and shoot me or stab me, yes. I feared for my life.
Did you have any beef with him before you hit him?
No, sir. In the beginning of the video, I stood beside him for 5 seconds, looking dead at him and never fooled with him. I had no reason to fool with him.
And you heard Mr. Hennessy's testimony that he couldn't testify that he didn't say something threatening to you, but you specifically recall something that caused you fear of serious bodily injury. Is that correct?
Had he not said nothing to me, I walked straight past him.
And when he said those words to you, "I've got something for his ass," with him standing with his hand under his shirt, with the weapon side away from you, what did that make you think?
Well, Tyler already was telling me behind me that his wrist was broke, talking about how bad it hurt. So then we get to that, so I'm already on alert. And then I see him in a drawn position, which is, to me, textbook. And like I said, I see it's his left hand, but I don't know what hand he is, in that position. I had to make a split-second decision, and that was, had I not had nothing in my hand, I'd have used my hand. But that's just how it fell because I had 2 beers in my hand.
That's all I have, Judge.
Thank you. Cross.
Okay, so I think you had stated earlier, this, where my icon is, that's you,
It looks to be.
and this is Tyler, your friend.
Oh, yes, sir.
Okay, I just wanted you to watch that for a second.
Okay.
Was Tyler pushing you back, trying to get you to go? Why were you walking backwards at that point?
Tyler's being shoved by the bouncer at this time. You can't see it in the video. I was standing there. And so, with that happening, I was also being shoved from Tyler because he was between us, me and the bouncer.
So your friend Tyler was also pushing you? Like, before you actually swung the beer bottle, Tyler was pushing you?
Once the bouncer shoved us, Tyler's hands were out, correct, and it caused me to move forward, but I didn't, with the guy in the posture he was in, I just didn't feel comfortable walking past him.
Is it correct that a very easy way to de-escalate a situation is to remove yourself from the situation?
Yes, that is the best way.
Okay. Why didn't you remove yourself from this situation? Why did you choose to swing the beer bottle?
In all due respect, if it's going to be me or him, it's going to be him.
Did it shock you to find out that the victim had no weapon on him at any time during the altercation?
I never was aware of that.
I'm sorry, the objection.
There's been zero testimony that he had a weapon at this point. And so it would be speculation for him to even testify about that.
The objection's overruled. You can end.
Would it surprise you to know that there was no weapon found on the victim at any point during the night?
No, I wouldn't know that. But, I mean, I don't have x-ray vision, so I can't check him out before this happened in this split second, sir.
Okay. At this time that you swing the beer bottle, is it your position that you were only in fear for your life or your safety?
No.
So you were, as you asserted in your motion, you were in fear for your friend's safety as well?
Both of us, correct.
Why was your friend pushing you to go out the door then?
Because he was being shoved from behind.
So was your friend not worried about his safety?
My friend was worried about getting out with me. So he had a 8-foot guy behind him, excuse me, I don't know how tall he is, but the dude was shoving both of us. There was no stopping him.
After you strike the alleged complainant with the beer bottle, would you agree that your friend actually just pushed you more to get out of there?
It wasn't by the bouncer, right? That was by your friend, because the bouncer is 3 feet behind him.
His hands on his back, but I mean, yeah, we was trying to get out because what had just happened. I mean, just walked away from the instruction of the bouncer.
Okay.
I didn't run or anything. I just walked off.
And you would agree that up until the point that the bottle made contact with the victim's face, you and the victim had not had any personal altercations between each other?
Not until he said what he said before the strike.
I have no further questions, Your Honor.
Redirect.
Of course, it's on the show. I don't have anything further, Judge.
Thank you. Yes, sir, you can step down.
Thank you, Your Honor.
Any other witnesses, Mr. Pop?
No, sir, Your Honor.
Any other witnesses from the state?
No, Your Honor.
Okay, argument?
Yes, definitely, please let, if I can let the victims go through the
Yes, sir. Sure.
I'll let you.
Thank you. Argument? Mr. Bivens?
I believe it's my brother's son. I believe I have to go first.
Yes, sir, please.
Your Honor, I think in this case, I think there was some discussions early on about the victim not being able to necessarily remember some things clearly. There are some discrepancies in the affidavit of complaint. I just would like to point out, as we've seen in this video, not only was the victim shoved into a bar where he actually hit the back of his head on the bar, he also was hit with a glass bottle. So I just want to point that out to the court to help illustrate why there might be some discrepancies in what he's remembering right at that time. With that being said, this is one case where we're very, very fortunate to have a surveillance video that is able to clarify a lot of those discrepancies. As you're looking at the video, there is a lot of evidence that shows that the victim, at almost every single point in the incident, was the least aggressive person in that room, with the exception of the very beginning. And in the beginning, he's getting shoved into a bar. And after he's getting shoved, being held by somebody who's not even of his own party, he's calm. He's not doing anything. He has there's no, you don't even see him necessarily yelling. You don't see any sort of flaring of the arms. You don't see him bow his fists up. You never see him once say anything to the defendant at that point in time, and you don't see him really say anything to the guy that shoved him. I think it's interesting and a little bit ironic about, we're talking about the safety of the party of the defendant, when we saw a perfect example of how you could have handled this without a deadly weapon, and that is to remove that person off of your friend and simply push them or throw them to the side, as we saw Tyler in the video do to the other Tyler. So I think that's something that needs to be pointed out, is that there's so many other ways that this could have been handled if, in fact, that statement that was allegedly made was made. The only self-defense really that we had here that we can see is actually the Tyler throwing the other Tyler off of his friend. He actually physically saw that Tyler grab his friend and shove him into a bar, and he pulled him off and threw him to the ground. That's the only evidence that we've seen and that we've heard of in this hearing. As you go forward, you see the fight or the altercation goes around the bar, and it doesn't even involve the defendant and the victim in this case. The victim has his hands on his hips. Okay, there was a point made by defense counsel when he was talking to the victim, and the victim's like, "You can see that I'm not saying anything," and the defense counsel goes, "Well, we can't see your back, or we can't see the front of you." Well, if he's going to take that position, the same position must be taken then with respect to the defendant and the victim. The defendant was in front of the victim. How is he going to see if his hand's underneath his shirt or not? As far as he knows, his hand's just on his hips. Having your hands on your hips doesn't automatically put you in a dangerous position. I think at one point in time, at 37 seconds in the video, I think that's a very common number that's been stated, we see the defendant kind of walk up towards the victim in this case, and you actually see the victim take a step back. That's the opposite of aggression. All he does is he keeps his hands on his hips. His hands are, at that point in time, when he's seeing and he's right in front of him, his hands are right there. The victim makes no furtive movements. He doesn't do anything aggressive with his hands. He keeps his left hand here, and then as the defense counsel stated, at one point in time, somebody might have even had his hand on his right arm. So he was, if anything, more constrained than the defendant ever was, and he was the one that got struck in the face with a beer bottle. I think the video really does speak for itself. You have an incident here where the initial incident occurred. Almost 30 seconds goes by, or more than 30 seconds goes by, where the victim and the defendant are completely separated, and the victim is actually separated from the incident more so than anybody else, and he's standing off to the back. And then as the defendant, who, if you look at that video, he's getting kicked out. It looks like he's getting upset that he's getting kicked out. His friends are trying to tell him to get out. You see his friend push him multiple times to get out, and as he's getting out, he chooses to strike the victim in the face with a beer bottle, causing 60 stitches. This is not an instance of stand your ground. This is not what statute 776032 was meant to protect. It was meant to protect when somebody reasonably could infer that imminent threat or harm was about to come to them or a member of their party. It's very clear that the victim in particular in this case was not the aggressor at any point. The only point that you could maybe make an argument that he was when he was getting pushed backwards into a bar, and then after that was done, he had his hands up like, I don't even know what's happening. And then he walks around because people that he knows are getting into an altercation, and he's sitting there watching. He didn't go and jump in. There was one person who went over to the other side of the bar and got involved, and it's the defendant. So we see one fight happen, then it gets broken up by the bouncer, and then the defendant makes his way over to the other side of the bar, and it just so happens that another altercation occurs. And then as the defendant is being escorted out of the bar by the bouncer, he hits the victim in the face with a beer bottle. That is not self-defense. That is not what this statute was intended to protect. And so for those reasons, the state respectfully requests that this court deny the stand your ground motion and allow this to proceed to a jury trial where a jury can decide what happened.
Thank you. Mr. Clark.
Yes, sir, Your Honor. Thank you. Just a couple of kind of procedural basic things, Judge. The statute allows somebody to use self-defense in the stand your ground statute if they are lawfully in a place where they are allowed to be, which he is in this particular case, and was not engaged in any criminal conduct, which by all the testimony there was no engagement in criminal conduct. Therefore, Mr. Lambert doesn't have a duty to retreat under the statute. I'm going to read, if I may, Judge, I'll get through it fast, but this is from the pattern jury instructions. I know you're very familiar with them. We've all used this particular instruction before in trials, but the pattern jury instruction for self-defense under the Florida statutes for stand your ground is in deciding whether the defendant was justified in the use or threatened use of deadly force, and I'm paraphrasing a little bit just to save time. You must consider the circumstances by which he was surrounded at the time of the force. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of force or threat of force. So it kind of boils down to the testimony that's been provided so far. Are the fears that Mr. Lambert had that in this statute is an objective, not a subjective standard for stand your ground, but would an objectively reasonable person that is trying to exit by a man who has already previously been involved in some type of scuffle that we couldn't see off the screen because there's no video for that, with a whole bunch of friends who are acting all...
So what was the testimony about the scuffle that happened off the screen? What did the alleged victim do? What is the evidence of that?
We don't have any testimony about that today, Judge.
Okay.
But that is not the test. The test is, at the time immediately before Mr. Lambert hit Mr. Hennessy, did he have a reasonable basis for having a fear of serious injury or bodily harm, and confronting a man who is standing there with his hand under his shirt, with his non-gun hand back, and he's standing in the video that we've seen with his hand underneath his shirt. The only time in this whole process that we've seen him standing there with his hand under his shirt in a position, and then there's no contradicting testimony at all that Mr. Hennessy said to my client, "I've got something for his ass." Now, was that directed at my client? Was that directed at Tyler, his friend? I don't know, but when anybody in law enforcement confronts somebody that's standing there in an altercation, that's standing like they're about to draw a weapon, and a man says, "I've got something for his ass," I think it's reasonable to use self-defense. And I don't know if you're going to spend any time going back and looking at the video or not, but
I've watched it quite a few times
I know.
while you've been here. Yes.
And but you will see that the grip on the bottle, it's very hard to see, but the grip on the bottle did not change until there was some recognition between those two. And that's probably at the time that something was said, or that Mr. Lambert actually sees him with his hand under his shirt. That is not a withdrawing way to stand. A withdrawing way to stand, if you're trying to not to engage somebody in any further action, is to stand with your hands out like this so somebody can see your hands, that you're not a threat, or hey, I'm not causing any trouble here, or stand with your hands down here. But when somebody's in a drawing posture like this, it is reasonable for somebody, especially that has knowledge because he has a carry and concealed weapon license that has training, that is a draw posture for a firearm or a knife. Textbook. And so I believe it's reasonable, even if he's mistaken, and the jury instructions allows for the threat not to be actual. It allows for somebody to have a mistaken perception that it doesn't end up being true that somebody has a weapon, but if somebody acts in self-defense, even if they're mistaken about it, as long as their belief was based on a reasonable basis, then they are immune from prosecution. And if I can, Judge, I'm sure that everybody has seen this case, so I didn't send it around. It's one of the seminal cases on stand your ground. It's the Bowie case. I'm sure everybody's familiar with it. I want to read a little bit from the Bowie case, which is 292 Southern 3rd, 471. And I'm probably going to get the... It looks like it's in Westlaw Box 13, 12, 13, 14. But when it talks about, and this was a case where a case was thrown out based on stand your ground in a not too dissimilar altercation that was shooting that. Clear and convincing evidence, which is the proof that the state has to bring forward in order to meet their burden, requires the evidence must be found to be credible. The facts the witnesses testify must be distinctly remembered. Mr. Hennessy did not distinctly remember any of the facts or what he said, and couldn't even deny that he had said something threatening to my client. Moving on in the quote, the witnesses must be lacking in confusion as to the facts in issue. And that's talking about whether the state is able to meet their clear and convincing burden. In this case, they have presented no witnesses that can, I'm sorry, Judge, that have been able to have credible facts, distinctly remembered. Explicit witnesses must be lacking in confusion to the facts at issue. The only person who's presented that has been the defense through Mr. Lambert's testimony. Mr. Hennessy cannot remember or even deny that he said something. The test in the Bowie case, the court goes on to say, furthermore, the trial court did not resolve the differing accounts of how the altercation transpired, and the evidence adduced at the stand your ground hearing was highly uncertain and conflicting, leaving the state unable to meet its burden. And I'll close on this, Judge. The first paragraph of the conclusion in the Bowie case really speaks as to the passion of these cases, because obviously tensions are very high. Everybody's passionate about this young man who's got a big cut on his face. And the court seems to suggest that we need to look beyond that and look to what it points out here. And this says, one can reasonably look at the facts of this case and say that it is not one in which the defendant deserves in a moral or public policy sense to be immune from criminal prosecution. In other words, in the Bowie case, the facts look bad or look scary. Whether the defendant deserves immunity in a moral or public policy sense, however, is not the question that the stand your ground law requires us to answer. The legislature has directed that a defendant who files a sufficient motion to dismiss on grounds of immunity is entitled to it unless the state clearly and convincingly establishes that he is not. The only evidence has come from Mr. Hennessy. He states he can't remember. That is not clear and convincing evidence. We have rebutted that by stating that Mr. Lambert had a reasonable belief that he was in fear for his bodily safety and that of his friends, and we're asking for you to dismiss the case.
The thing that makes it so difficult for the court, and it was intended by the legislature, I'm sure, is the burden of proof that the court has to find, be clear and convincing. If it wasn't for that, if it was a lesser burden, it'd be a lot easier for the court. But the clear and convincing certainly shifts a huge burden on the state. And so that's what slows the court down. The only evidence is not just the testimony of the defendant, it's the video. Would have been a lot easier decision for the court to rule in favor of the state if the defendant didn't take the stand. The defendant taking the stand and saying, that the alleged victim stated, I have something for his ass, that's what slows the court down a great deal in relation to clear and convincing evidence. But if the court boils it down, it's saying that an alleged victim that puts his hand on the hip or has the posture that's in the video. An alleged victim's friend gets into a fight. The alleged victim says, "I have something for your ass," and then the defendant gets to hit him with a beer bottle. Is it clear and convincing evidence that the defendant is justified in using or threatening to use force, except deadly force, against another when and to the extent that the defendant reasonably believes that such conduct is necessary to defend himself or herself or another against the other's imminent use of unlawful force? The court finds that the state, and I'm going to get this in a double negative, so I don't want to do that. By clear and convincing evidence, the state has overcome the immunity arising from that sentence. Then, as Mr. Klotz points out, there's a parade too. A person, meaning the defendant, is justified in using or threatening to use, well, that's only deadly force, I'm sorry. So, again, a difficult decision for the court. The video is the thing that carries a lot of weight. It is undisputed on what the terminology was, what was said by the alleged victim. There's no dispute of that. But is that in relation to the other facts of the case? Does that allow the defendant to prevail, especially in light of the relatively low burden? And the defendant doesn't have any burden, the state's got the burden. The court finds that by clear and convincing evidence, the state did overcome the immunity, so the motion to dismiss under stand your ground respectfully is denied. So Mr. Gomez, if you'll prepare a proposed order on that, if you'll prepare it in Word, provide it to Mr. Klotz within 5 working days from today. If the two of you can't agree on the proposed language, Mr. Klotz, if you'll provide the court and Mr. Gomez with a red line of that order. So I'll see, Mr. Lambert, is it on May 8th?
Well, Your Honor, may I address the court?
Set for Monday? Okay, yes, sir.
Your Honor, when I have appealed these types of cases before, I'll file a writ of prohibition. Because it is an issue of whether he's immune or not, we would ask for a continuance until I'm able to file the writ of prohibition. I think that would stay it anyway, at least it has in the other cases that I've had in this particular situation, and that would be our intent. So I'm asking the date that you have said, May 8th, is that a trial date or a docket day? Or
Our docket day is Monday, the 20th.
Right.
I think that's when we're set at this point.
Knowing that I'm going
I think we
to...
were set Monday, and then I think, did we set it for? Because we came up Monday, and I think we said.
Okay.
We said we'd leave it open until today.
Right, because I didn't want it to totally fall off the radar. If it was going to be continued one cycle, it would be May 8th. Is that enough?
That'll
time?
give us time, Your Honor. Thank you.
Okay.
May we
No objection.
Please, yes, sir. You'll get that, Madam Clerk.
may we approach, Judge?
Yes, sir.